Members, going down the agenda, City Attorney, do we have anything to report?
Yeah, Mayor, one item from closed session. That is that Council voted 403 with Bolton, Mosier, Kalmick abstaining to support by amicus the petition for Supreme Court review in the Gloria Johnson versus City of Grants Pass, United States Court of Appeals, Ninth Circuit case 20-35752, 20-35881, as it appears on the agenda.
City Attorney, I understand you have a presentation, important presentation. Would you like to do that at this time?
Sure.
He's going to.
I'm sorry, point of order, Mr. Mayor. Wouldn't this, on the agenda, this is agendized after public comment? Just wondering why we're doing this before public comment?
Well, I wanted the City Attorney just to go ahead and go make his presentation, then we'll go to public comments.
Right, but the agenda shows that it's this. I'm wondering this is so that the effect of this can be seen by the entire crowd instead of prior to after public comment?
We can move it. If you want to move it, that's fine.
No. It can be moved up before public comments. There's no problem with that.
Yeah. Okay.
Yeah.
Just seems rather irregular.
Okay.
And unwarranted. I mean, I also received this
Okay.
presentation 20 minutes before the meeting started at 3:30. It's a 66-page slide presentation, remarkably similar to the one we had 2 weeks ago, with the same unfounded information.
Unfounded is your opinion, but again, back at that point, we did say that the City Attorney was going to come back for part 2 of that, and I'm glad he broke it up and didn't put it in one meeting.
Right, but it's,
So-
I mean, I was able to actually review it in the time that I had, and it's remarkably similar. It's about 8 slides longer, but it goes over an enormous amount of the exact same information we received 2 weeks ago. It was 45 minutes to an hour presentation last.
Okay, well,
last time,
then you'll know the presentation well. City Attorney, please move forward.
Okay.
Mayor, can I say something for a moment? A lot of people call in and they ask what time to come for public comments, and we've said 6 o'clock. This could take an hour or so. Do you really want to do this report first? We have 88 people signed up to speak. 88.
Oh, I understand that.
I can go quick.
We'll go quick then. Please, City Attorney, go quick.
Thank you. So, thank you, Mayor. I will go through this expeditiously, and as you indicated, it is an important report. There is a QR code on the screen. If anybody wants a copy of this file, they can download it by scanning the QR code. It's the same QR code on the subsequent slides as well. So this is a presentation in response to Councilmember McKeon's H item of December 20th, 2022. And the H item provided a lawsuit was brought in 2018 by former attorneys Neil Moore and Scott Field against the City of Huntington Beach and City Attorney Michael Gates. For years, City Council met with handling attorneys, including outside attorneys from Greenberg Gross, in closed session about the lawsuit. In 2018, City Council viewed this lawsuit as frivolous. The 2018 City Council viewed this lawsuit as frivolous. Else the City Council would not have met in closed session multiple times to direct the handling attorneys for the 3 years to prepare the lawsuit for trial. The City Attorney is the city's attorney designated by the people at election time. And again, this is straight from the Council McKeon's H item. The city charter is clear about this, and City Council was not at liberty to hire their own attorney behind closed doors to conduct any investigations or perform any legal work. This Steele investigation, in my view, was nothing more than a political witch hunt, all done in secret. The H item continues. Mr. Steele never interviewed Mr. Gates, the person at the center of the investigation, nor did Mr. Steele interview anyone from Mr. Gates's office, any of the Greenberg Gross attorneys, and he did not interview any of the council members who were actually present in the 9 closed session meetings and who made the decisions, witnessed firsthand Mr. Gates's conduct in the handling of the case. As a result of the H item, council voted 4-3 to waive the attorney-client and closed session confidentiality privileges for the closed session meetings on the Moorfield v. City Gates lawsuit for the sole purpose of allowing Mr. Gates to give his side of the story, to return to City Council, which is what we're doing now, with a public presentation on what was discussed and decided by council member votes in those closed sessions. The council also voted that night to waive the claimed attorney-client and other confidentiality privilege and any and all communications between the city, council members, and Craig Steele and his attorneys regarding the investigation. City manager to preserve all emails, texts, communications between the city and Craig Steele and his law firm, between the former city manager Oliver Chi and the law firm. And finally, council voted city attorney, after review of the aforementioned communications and invoices, returned to City Council with recommendations if any further action could be taken against the law firm for the spending of taxpayer money on the investigation done behind closed doors and away from public visibility. So just a recap of what that lawsuit was about. The lawsuit itself was filed in 2018 by attorney Neil Moore, who had voluntarily retired from the city attorney's office in 2017, and attorney Scott Field, who, even though having filed a lawsuit, continued to work in the city attorney's office for 3 years. Both alleged age discrimination and hostile work environment. The defense of the case was that those 2 attorneys, after many years of attempts at correction, refused to meet the expectations of the city attorney's office, and after many years of demonstrating very poor legal judgment, both were disciplined for lack of competence, of which had resulted in substantial monetary exposure to the city. In all of 2019 and 2020, the Moorfield versus City Gates lawsuit had been litigated aggressively. And for those 2 full years, the 2018 City Council repeatedly voted to take the case to trial and authorized payments of outside counsel. There was no merit to the case and no merit to settling. 2 years, and the previous City Council never expressed any concerns over the handling of the case. There was never any concern by anyone about attorney ethics or conflicts of interest. Then, November 3rd, 2020, an election occurred. Kalmick, Mosier, and Ortiz are elected, and the new city council is sworn in December 2020, constituted by Carr, Mosier, Kalmick, Posey, Douglas, Ortiz, and Peterson. Unexpectedly, during an April 19th, 2021 closed session, the new 2020 City Council voted 5-2 to settle the lawsuit for $2.5 million. While the new 2020 City Council voted 5-2 to settle the lawsuit, which had been considered frivolous by the previous City Council, I refused to settle. I was not part of the settlement agreement, and I did not consent to settle. I did not sign the agreement. I wanted my day in court, and I didn't get it. Nevertheless, I was dismissed by plaintiff attorney because they were pleased with the favorable settlement and wanted to put the case to rest. And just for the public's information, this is an organization chart for the city of Huntington Beach that appears in every budget every year. And the city attorney there listed on the far left, next to the city clerk, is next to the city council, and next to the treasurer, all report and answer to the people. There is no oversight of the city attorney by the city clerk or the treasurer or the city council. Likewise, there's no oversight of the city council by the city attorney, the city treasurer, city clerk, or anyone else. We all answer.
I will make an announcement that if there's outbursts, we will remove you. All right?
All of the elected officials listed there horizontally in the blue bubbles are answerable to the people. Section 309 of the city charter. The city attorney is elected by the people to, quote, represent and advise the city council and all city officers in all matters of law. Goes on to represent and appear for the city in any and all actions or proceedings in which the city is concerned or is a party. There's an administrative regulation on file with the city that states, quote, the city attorney at his or her sole discretion may choose to contract with outside legal counsel or provide the legal services through the city attorney's office. Once outside legal services are identified and retained, the city attorney's office will provide oversight and monitoring in order to control quality and costs of outside legal services. There's a Court of Appeal decision out there as well about the city's charter, Huntington Beach's charter, and the duties and responsibilities and the autonomy of the city attorney. And that Court of Appeal says, quote, the city council may hire other attorneys to help the city attorney discharge her official duties, but may not relieve her of such duties. Any such attorneys hired by the city council are under the city attorney's supervision and have no authority to give opinions or act independently of the city attorney. Case law on the topic of electeds says city attorney's powers are plenary. The city council cannot usurp the powers or duties of the city attorney. Courts have expressly recognized the rule that a public agency may not contract and pay for services which the law requires an elected official to perform. Also, during that April 19, 2021 closed session that I mentioned previously, the newly elected council member, Dan Kalmek, called for an independent investigation into the city attorney's handling of the Moorfield v. City Gates lawsuit. Council member Kalmek alleged ethical concerns over conflicts of interest and overbilling by outside law firm Greenberg Gross. Those allegations, even after thousands spent on investigating, were never substantiated.
Again, isn't there
Council voted 5-2
open
to-
FPPC complaint against a former attorney in your office as a result from this?
Mayor, may I respond, and then may I continue uninterrupted? Yes, so the FPPC complaint has to do with a 1090 violation, has nothing to do with the lawsuit, it has to do with employment and conflict of interest.
Right, because the investigation was into how the case was handled, and there was questions
Thank you,
as
Mayor.
to how that happened.
Council voted 5-2 to have former city manager retain an independent investigator to investigate the city attorney and the case. So, on May 13, 2021, Oliver Chi officially hires Craig Steele of Richards Watson Gershon. Notably, the newly seated council after 2020 never voted to publicly waive any attorney-client or closed session privileges to allow the independent investigator to review the confidential lawsuit documents or related confidential communications. This is important. To properly waive any privilege or confidentiality by City Council, it must be recorded publicly. What is an independent investigation? Hiring an attorney for an independent investigation is used to achieve an objective or impartial review of the facts. Independent or special counsels are outsiders who impartially gather facts and impartially evaluate them. They are disinterested in the outcome of the investigation and have no financial interest in working with one of the parties. Importantly, independent or special counsels do not establish attorney-client relationship with the party who retained them to conduct the investigation. The city retains independent investigators all the time, and there is no attorney-client privilege established. If retaining Steele was permissible and everything was above board, why were the documents related to that retention not disclosed a year later? In 2022, Oliver Chi was requested repeatedly to produce records evincing the retainer in the work of Steele and RWG, and there was no response. The response was that no such records exist. So this is the city attorney asking for documents regarding the use of outside counsel and getting no response. However, the records produced later after the privilege was waived suggest otherwise. Here is a May 7th, 2021 letter between Steele and Oliver Chi representing the retainer of Craig Steele specifically for purposes of conducting the investigation. That was a year prior to the request for records. Another record that was produced, July 31st, Steele wrote to Oliver Chi, and it's notable that in the first paragraph, the second sentence states, "We take seriously the role that has been assigned to us and the need to provide impartial and independent legal advice and conclusions to the City Council." The first sentence of the July 5th, 2022 report that Steele prepared and published says the City Council requested in May of 2021 that his law firm provide an independent review of the city's handling of the employment-related lawsuit against City Attorney Michael Gates and the city, brought by two now former employees in the City Attorney's Office. In another letter Steele sent, this time to the FPPC on December 23rd, 2021, he again states his independence. "I have been retained to serve as special counsel to the City Council of the City of Huntington Beach for a review of the city's handling of a lawsuit." So Oliver Chi then hired Craig Steele. Craig Steele worked with Oliver Chi for years in Monrovia prior to Huntington Beach. He worked with Mayor Joe Kalmack for years as city attorney of Seal Beach. The California League of Cities advises refrain from selecting lawyers to serve as independent or outside counsel who are friends or colleagues of council members to avoid the appearance of cronyism. Steele boasts that he worked for partisan, and this is in his own bio published on the internet, he boasts that he works for partisan political figures such as U.S. Senators Gore, Alan Simpson, and Lloyd Benson, Assembly Speaker Willie Brown, Los Angeles Mayor Tom Bradley, and Honolulu Mayor Frank Fassi. However, Steele was not even qualified to review a litigation matter. In the second paragraph, Steele basically stated he had no litigation experience. And this is from his own bio. He says, "I have been a municipal lawyer for my entire career of nearly 30 years, with over 25 years as a sworn contract attorney in 4 cities. I have been the city attorney in Monrovia since 2002, where former city manager Oliver Chi served for a period as city manager prior to coming to the city of Huntington Beach." So no litigation experience. This review was also outside of his expertise. In his report of July 5th, 2022, he wrote in the third paragraph, "I was engaged to look at the record and evaluate how litigation was handled and advised whether it might have been handled in a different way." But he was not a litigator, he was a municipal attorney. A review of emails with Steele show that Steele gave the 2020 City Council advice on hiring him. So that's an email Oliver Chi sent to the entire council except for Eric Peterson with a letter attached where Steele, in a not so independent way, was advocating for him to be hired. Next slide. In another email, the Steele gave Mayor Dalglaze talking points on advocating the hire of him. Another email, Steele assisted Oliver Chi and 2020 council members with 2022 proposed charter amendments. Also, a recent review of invoices show that from 2020, the city paid thousands for legal services to Craig Steele and his law firm, where he was an equity partner. These legal services were quietly requested by former city manager Oliver Chi without city attorney consent or approval, and therefore no oversight or accountability. Those services included consulting on the Shane Alathis case, which we had already sent out to a different law firm, so we were essentially paying double for that time spent on that case. Preparing the 2022 charter amendments for the 2020 City Council. Advising on election laws. Attorney work done by him on separation incentive program. Attorney work done on DBFOM, Public Works. Various personnel matters. Consulting with council members on politics. And providing talking points to the mayor regarding hiring outside legal counsel. And all of this was done outside of the city attorney's office without any oversight or accountability. In a recently discovered email, Steele revealed his bias and lack of impartiality or independence. On December 16, 2021, Steele wrote to Chi about the upcoming 2022 proposed charter amendments. Quote, ask the voters to improve the system, and then he can take all of his arguments and shove them up his ass. Not so independent. In the 2022 July 5th Craig Steele report, after the city spent over a year of time on this independent investigation and thousands of dollars paid to Craig Steele and his law firm, he states, first sentence of his conclusion in his lengthy 30-something odd page report, I did not find any evidence of any violation of the law by city attorney, current members of his office, or Greenberg Gross. And a brief history of the closed sessions.
Again, we will, listen, we will remove anybody who does this. At the end of the day, you're going to have all 3 minutes. I believe there's over 88 speakers, and you'll have your time. We give you your time with respect. Give the city attorney the same respect.
Thank you, Mayor. Thank you very much. On January 10, 2019, the city was served with a lawsuit. On the very same day, I internally announced my recusal from the lawsuit and designated Williams to conduct a request for proposal by outside firms to handle the case. On January 22nd, 2019, I announced my recusal verbally and in writing to the City Council. And the City Council voted 7-0 at that time in 2019 to retain the law firm of Greenberg Gross. What is a recusal? An attorney steps away from representing due to a conflict of interest, which is a legal determination by a lawyer. Defendants still communicate, even if they're attorneys, defendants still communicate and participate in the attorney-client relationship with their attorneys. There is no conflict of interest to participate in the litigation as a defendant. As you can see, more closed sessions occurred. There were more approvals by the council to pay attorneys' fees and to keep on track to take the case to trial. In September 8th, 2020, the council rejected a demand or settlement to offer to settle by plaintiffs it's $5.8 million was their demand. Council rejected that. Council votes 7-0 to authorize another $500,000 to Greenberg Gross in attorney's fees. So again, the next slide shows April 19, 2021, suddenly the new council settles the case and orders the independent investigation. This one's hard to read, so I'll read it for you. There were many concerning closed sessions held, often listed as, quote, significant exposure to litigation pursuant to paragraph 2 of subdivision D of the Government Code, section 54956.9, in which I was excused by the city council majority. Council member Eric Peterson also left the room believing that such a conference of city council behind closed doors without the city attorney present is a violation of the Brown Act. A review of those legal invoices and emails shows that the subject matter discussed was not potential litigation with significant exposure to the city. Rather, they were closed doors discussions about Steele's independent investigation. There was no Brown Act exception for a city council body to go into closed session to discuss an independent investigation of another elected official. And those meeting dates are listed for those closed sessions. In another email, Oliver Cheese sends to Steele my confidential closed session emails intended to be viewed only by city council. In another email, Oliver Cheese wrote, over my objections, based on my privilege, he ordered a search of the email server to get to my privileged emails. And those are my private communications between me and the Greenberg Gross attorneys. Nobody is entitled or allowed to invade that attorney-client privilege. Yet Oliver Cheese ordered those over my objection to be searched for and produced. Steele improperly attended closed sessions in 2020 with City Council without the city attorney. I objected in writing to City Council improperly going into closed session in violation of the Brown Act. I wrote, Oliver, I'm informed that your review of the handling of the Moore v. City case is on for closed session. I assume, since it isn't plainly listed on the agenda, you have it as potential litigation. What is the Brown Act justification for taking this review of handling of the case into closed session? There is, or I'm not aware of any Brown Act basis. No response. In another email, Craig Steele insisted that I should drop my attorney-client privilege claim regarding my private attorney emails. Oliver Cheese sends my attorney-client privilege emails to Steele, notwithstanding my previously placed objections. He wrote, hey Craig, just to confirm, I uploaded 54 new emails from Gates to Greenberg Gross onto the Box account under the file titled Gates Emails to Greenberg Gross, and then he provides a login. There are also evidence of council members consulting with Craig Steele about political concerns. The takeaways from the closed sessions, the previous city council voted, and that's the 2018 council, voted regularly to approve the $1.5 million spent on Greenberg Gross legal services. I recused myself on day one and always acted in the lawsuit as a defendant with no conflicts of interest. The case was viewed by the 2018 City Council as frivolous for 2 full years until the new 2020 City Council was seated, then it was settled. The $2.5 million settlement yielded a $1 million payout to Scott Field, who ran for city attorney, and was endorsed by a couple of the council members. Again, at the April 19, 2021 closed session, the independent investigation was called for. Yet, because of allegations of ethical concerns or conflicts of interest, yet neither Kalmick nor Mosier and ultimately Bolton were present during any of those closed session discussions or meetings where this lawsuit was discussed by the previous city council during the previous 2 years. There was no basis or firsthand knowledge of any of the concerns. A review of the records revealed that on multiple occasions, Oliver Cheese forwarded to Craig Steele highly confidential and privileged closed session memos spanning 2 years prior that had been prepared by the city's attorneys. Oliver Cheese and Craig Steele met in closed session with the new 2020 City Council on numerous occasions to discuss the independent investigation. Yet there was no Brown Act authority to do so, and no confidentiality or privilege attaches to such closed-door discussions. Peterson refused to participate on the objection that the meetings were improper. On multiple occasions, Oliver Chi forwarded to Craig Steele highly confidential and privileged ongoing email communications and attachments that the city attorney had directed to the city council. For months, Steele helped develop and provide counsel for all the 2022 charter amendments. Steele helped Del Glaze and others with talking points to be read at city council meetings regarding the 2022 charter amendments, advocacy, and ability to hire attorneys. Among those charter amendments, the initial proposal was to take the elected city attorney away from the people and convert the city's form of government to an appointed attorney, one hired by council. Steele was involved in helping with this and would have benefited financially from it if his law firm was given the legal work. While I asserted attorney-client privilege between me and the Greenberg Gross attorneys over my rightfully placed objections, Chi secretly directed IS staff to access the email server and surreptitiously take my privileged and confidential emails. Then Chi forwarded 54 of my private email communications with my attorneys to Craig Steele. Oliver Chi and Craig Steele had circulated drafts of the RWG Craig Steele investigative report to all city council except for Peterson, soliciting a review and feedback by all the council members, a meeting subject to the Brown Act. Council members did review and provide feedback. Peterson had requested of Oliver Chi to not include him in those communications on belief that it was improper. Craig Steele and/or his staff met over many months at City Hall and Zoom with council members to discuss the independent investigation and proposed 2022 charter amendments. Craig Steele met with Oliver Chi, Kim Carr, Mike Posey, Dan Kalmack, Rhonda Bolton, Natalie Mosier, and Barbara Douglas to invade attorney-client privilege communications with the city attorney and gather information about prior confidential closed session meetings with the city attorneys and/or Greenberg Gross attorneys.
But I thought you said that he didn't interview anybody that was in the 2018 council on slide 2 or 3. When you say here that he met with Mike Posey and Barbara Del Glaze, who were on that council, and were in those 8 closed session meetings.
Well, there is evidence showing that he asked about other issues. It wasn't about the investigation. Or it was certain topics asked about, but not about my conduct. It had nothing to do with my conduct.
What happened to Short?
Steele knew, we're getting there. With the interruptions are dragging it out a little bit here. Steele knew or should have known, based on the city's authorities, that contracting around the city attorney in violation of the people's designation of the city attorney as the city's legal counsel was void. Those contracts with Steele were void. Notably, I was never interviewed by Craig Steele or his law firm as part of the independent investigation of me. Normally, the subject is interviewed. None of my staff were interviewed. None of the Greenberg Gross attorneys were interviewed by Steele. None of the following former council members who were key witnesses to the subject closed sessions were interviewed: Peterson, Hardy, Sameta, or Brendan. Yet, records show Bolton, Mosier, and Kalmack, who were not present during any of the handling of the lawsuit from 2019 through its settlement, were not present for any of the closed sessions and had no information about what had happened, were interviewed. Even though Steele claimed to have been independent, special counsel, when asked for records, he claimed attorney-client privilege, which is not possible if he was commissioned to conduct an independent investigation. He worked for Chi and Monrovia. He met with and communicated with Kalmack, Bolton, Mosier, and Chi regularly in person by email during improper closed sessions. He shared early drafts of his report with the city council and asked for feedback. He received highly confidential city attorney emails and closed session attorney work product memos for the past years, while having no attorney-client privilege relationship as an independent counsel to protect those. In December 2021, email to Oliver Chi, Steele made a statement against me which revealed his bias, undermining his independence. He boasted about working for highly partisan politicians in the past, So possible next steps, which I'm not asking for a discussion or a vote tonight, but Steele's conduct is referable to the state bar. The city can consider to challenge whether to challenge the law firm on the legal fees billed for the improperly retained services, and the city can consider referring the concerns about the violations out for further investigation and handling. I'm just going to leave it at that.
And yet you have not.
Thank you.
Mr. City Attorney, what about, I mentioned it last time, the former city manager, Oliver Chi, accessing the server to release your private attorney-client privilege emails? What about next steps on that? To me, how is that legal?
Yeah, well, it's not.
In the closed session.
Yeah.
Disclosing the closed session, isn't that a misdemeanor?
None of those things are not legal, and they can be, as I said, further investigated or referred out for further investigation.
Councilman.
But yet, you have not refuted a single thing that was in that 68-page report. And this new council majority removed that report from the public record unless you send the city clerk an email. You can request a copy of it and read it for yourself. You haven't refuted any of the facts in that. And the fact that the city had outside counsel who was... The reason I brought this forward was when I came on council, I was given the record along with the billing, and I saw a gentleman who worked for the city who then went to go work for the law firm that we'd hired as outside counsel and was billing us for that. And now there's an open 1090 investigation for creating contracts.
Actually, I don't think you want to misstate the allegations in the FPPC complaint. They are what they are. I don't think that that's accurate. I wouldn't advise
I'm giving you
misstating them.
my view of when I was reading these billing reports.
I could easily, in part 3 of this report, go through the Richards-Watson-Gershon report and pick it apart.
I would love for you to do that.
Okay, excellent. I'd be happy to.
I would love for you to do that.
Thank you.
So audience, we have a part 3 coming up
Yeah.
next time.
Thank you.
With that,
Mr. Mayor, if I could
Thank you,
make,
Mayor.
may I make observations, please? Yeah, so if we're going to have a part 3, I would really love for someone from Richards, Watson, and Gershon to be able to come and rebut some of the things that you're saying. I didn't say anything during part 1 of your presentation about some of the factual errors that I heard because I was part 2. You would have an opportunity to correct those things, but I did not hear any correction of some of the factual errors, and so I'm going to mention a few of those, not a lot, since this already has gone on longer than necessary. But for example, you repeatedly mentioned that a new council was elected and seated, and then suddenly the case was settled. So those council members joined in November or December of 2020, and the case settled when, in April 2021? So that's like 5 months. That doesn't strike me as a sudden 180-degree turn. And councils do not settle cases without getting a recommendation from someone. And so as I sit here today, I do not believe that council just magically, suddenly decided that they were going to settle a case that had been litigated for 2 years. In Mr. Steele's report, he doesn't know what the reason is for the 180-degree turn. He says that in the report, but there was some reason. Does anybody care to share what the reason was for suddenly deciding to settle? I also understand from his report that the insurance carrier decided that it was going to pay the maximum amount that it was liable for or something like that. So to put this in terms that people can understand, like everyday things. So you have a car wreck. Your insurance carrier says, ooh, hey, okay, we're going to settle this for the policy limits. What does that say about your driving? What does that say? So, another factual issue, Mr. Steele did not interview me for purposes of this investigation. He did not. I talked to Mr. Steele after I was assigned to the committee, the ad hoc committee, to deal with this issue. And so I really, I see that you were, this whole thing, I guess, really messed with your ego or something like that. And Councilmember McKeon, I understand, that you're trying to do Mr. Gates a favor by giving him an opportunity to rebut the things in the Steele report, but the substance of the findings, which is that he mentioned Rule 1.7 of the California Rules of Professional Conduct repeatedly and made the suggestion that he doesn't think that things consistent with that rule occurred during the handling of that case, and that's just his finding. I'm just reading what his finding is. But I just don't think that this helped. I do not. So that's it. That's all I have to say.
Mayor, may I comment? Yeah, so one of the reasons I appreciate Councilmember McKeon bringing this forward and the council voting to allow me to present my side is because for nearly 2 years, I sat here not able to defend myself or reveal myself when members of the council sat here and leveled all kinds of accusations against my office and me and the attorneys in the case for 2 years. So it really was a welcomed opportunity, Councilmember McKeon, to actually present the other side, because waiving privilege is necessary for me to present the other side, and the previous council wouldn't have do that. As far as the Richards, Watson, Gershon coming here to give their side of the story, they investigated this for over a year on the taxpayer's dime to the tune of $90,000 plus, and they issued a 30-page plus report. They had their chance. I'm not sure what else you expect them to come and say. They had a full-throated effort on this issue. They presented a full report, and at the end of all of that, it found no wrongdoing. So, you know, Mayor, I just want to thank the council for giving me this opportunity. Hopefully, you know, we can put it to rest. But as Councilmember McKeon stated in his H item, and as we found, there was some impropriety. And you know, if we're going to honestly look at the way a lawsuit was handled, you don't hire somebody who's the friend of another decision maker or two in the city who doesn't know anything about litigation. So he's supposed to evaluate the handling of a lawsuit. I mean, the whole thing stinks from top to bottom. So you want to have a real investigation? We can have a real investigation. But I just want to appreciate this opportunity.
And from my perspective, I wasn't there, but at the end of the day, stealing someone's attorney-client privilege is not anything about ego. That's violation of the law, period. So with that, we have a lot of speakers. Thank you. I'm looking forward to number 3 coming up in the future.